बिलीफ। ठीक है, नेक्स्ट, एसेंशियल ऑफ टॉट्स। टॉट्स के एसेंशियल प्रैक्टिस क्या हैं? जैसे पहला, एक्ट और ओमिशन। एक्ट या ओमिशन से किया गया कार्य इज वेरी इंपॉर्टेंट। देयर मस्ट बी सम रॉन्गफुल एक्ट, कोई रॉन्गफुल एक्ट होना जरूरी है, इंक्लूडिंग ओमिशन टू परफॉर्म अ लीगल ड्यूटी। लीगल ड्यूटी, एक्ट इज रॉन्गफुल, एक्ट रॉन्गफुल होना जरूरी है इफ इट invades any of the three rights of a person: good reputation, property, and his right of bodily safety, and the Freedom Municipal Corporation of Delhi versus Subhamati. Delhi versus Subhamati. It was the duty of the corporation to keep the clock tower in proper repairs, and if falling of the same result in the death of some person, the corporation would be liable for its omission. Next. Torts where malice is relevant. ठीक है, जहाँ पे देखा जाता है कि अकृत्य जहाँ पे दुर्भावना प्रासंगिक प्रासंगिक है। malicious prosecution, nuisance, conspiracy, maintenance, deceit, and injurious falsehood. और क्या? Injurious falsehood. In certain cases of defamation, defamation के certain cases में, the defense of qualified privilege is available if the publication was made in good faith. The presence of malice negatives good faith. Malice may result in increase of damages for an otherwise ordinarily liable assault or trespass. Torts where malice is relevant. Malicious prosecution, nuisance, conspiracy, जो कि हमने पहले देखा, सेम थिंग, सेम बात कही है पूरी यहाँ पे। ठीक है, दिस द थिंग, ठीक है, द प्रेजेंस ऑफ द मैलिस नेगेटिव्स गुड फेथ, malice may result in the increase of the damages for an otherwise ordinarily liable, ठीक है, assault और trespass, सिमिलर सेम थिंग की है। ठीक है, ये आप हिंदी में देख सकते हैं। ठीक है, मैलिस इन फैक्ट, मैलिस इन फैक्ट, एक्सप्रेस मैलिस। एक्सप्रेस मैलिस क्या होता है? When a defendant does a wrongful act with a feeling of spite, with a feeling or spite, vengeance or ill will, the act was said to be done maliciously. As a general rule, malice in the sense of improper motive is entirely irrelevant in the law of torts. क्या है? Entirely irrelevant है torts के law में। Cooley J once, this was jurist, once remarked, malicious motives make a bad case worse. Bad case हो गया, worse बनाता है, but they cannot make that wrong, which is in its essence lawful. South Wales Miners Federation versus Glamorgan Coal Company, this is the case law, explains that a wrongful act isn't converted into a lawful act. जो wrongful act है isn't converted into a lawful act by a good motive. टाउन एरिया कमिटी वर्सेस प्रभु दयाल 1975 केस लॉ। जब भी आप लिख रहे होंगे एग्जाम में, द मोस्ट इंपॉर्टेंट थिंग इज, अगर आपको ये ईयर लिखना है तो ईयर शुड बी करेक्ट। ठीक है, सेक्शंस जो वहाँ पे एप्लीकेबल हैं वो भी सही होना चाहिए। इन दिस केस व्हाट हैपेंड, द डिफेंडेंट्स म्युनिसिपल अथॉरिटीज थे had demoralized the illegally constructed building of the plaintiff. Municipal commissioner was alleged to be an enemy of the plaintiff. Court, rejecting the plaintiff's contention, observed that merely because some officer has malice against a citizen who has committed a wrong will not render the action of the authority invalid if it is otherwise legal. Malice in law. Malice in law. Implied malice. Scherer versus Shields. The case law is 1914 का case. It was observed that a person who inflicted an injury upon another person in contravention of law isn't allowed to say that he did so with an innocent mind. It is not allowed. He is taken to know the law. उसे लॉ की जानकारी होनी चाहिए, and he must act within the law. So लॉ के कानून को फॉलो करना चाहिए। Wrongful intention. Wrongful intention क्या है? Is presumed in case of an unlawful act done without just cause or excuse for want of reasonable or probable cause. Smriti S.R. Venkataraman versus Union of India. SR Venkataraman वर्सेस यूनियन ऑफ इंडिया 1979 का केस है ये. The term malice, wrongful act done intentionally without just cause or excuse. malice क्या है? एक wrongful act जो कि किया जाता है intentionally and the cause or the excuse has been used in two different senses. दो senses में इसको use किया जाता है. The first one is malice in law and the second is malice in fact. वो है malice in law और malice in fact. Brooke versus Boole 1928. A and B entered Jay's premises to search for an escape of gas. Each one of them in turn applied naked light to the gas pipe. A's application resulted in an explosion, causing damage to Jay's premises. In this case, even though the act of A alone had caused the explosion, but both A and B were considered to be joint tortfeasor. ये एक न्यू टर्मिनोलॉजी है, हम आगे देखेंगे. एंड लाइबल फॉर द डैमेज. टॉर्टफीसर यानी जॉइंट टॉर्टफीसर कहते हैं साथी को, ठीक है, साथी इन योर क्राइम, द पार्टनर इन द क्राइम, दैट इज नोन एज जॉइंट टॉर्टफीसर इन लाइक शॉर्ट. Torts where malice is relevant, जहाँ पे relevant है malice. Malicious prosecution, nuisance, conspiracy, maintenance, deceit, and injurious falsehood. In certain cases of defamation, the defense of qualified privilege is available in the if the publication was made in the good faith. The presence of malice negatives the good faith. Malice was result in increase of damages. Damages can increase for an otherwise ordinary libel, assault, or trespass. Recent trends में देखा गया, the recent trends isn't only in making malice irrelevant but also under certain circumstances liability arises even without any negligence on the part of the defendant. In most important case है MC Mehta, the principle of absolute is stricter than strict liability, absolute liability has been recognized. The Worksman Compensation Act 1932 and the Motor Vehicle Act provides for compensation to the victims without going into the questions of fault or negligence. When two or more person commits a tort, जब दो या दो से ज़्यादा पर्सन टॉट कमिट करते हैं, acting in furtherance of common design, they are known as joint tortfeasor. I told you ना, the partner in the crime. The common examples of joint tortfeasors are, common examples हैं जैसे principal and agent, master and servant, and partners, vicarious liability, liability of the innocent joint tortfeasor, the innocent. If through no fault of his own, a person gets mixed up in the tortious act of the others so as to facilitate their wrongdoing, he may incur no person liability, but he comes under a duty to assist the person who has been wronged by giving him full information and disclosing the identity of the wrongdoers. Norwich Pharmaceutical Company versus Customs and Excise Commissioners. One case law. Next, Kushro versus N.A. Gusar. Kushro versus N.A. Gusar, 1970 case law. Plaintiffs filed a suit against various defendants for defamation. Meanwhile, one of the defendants tendered an unconditional apology to the plaintiffs. The plaintiffs accepted the apology and decree was passed accordingly. The other defendants contended that the release of one of the joint tortfeasors extinguished the plaintiff's right to sue the remaining defendant and claim damages from them. It was held that this compromise could not be treated as to be a full satisfaction for the tort alleged to have been committed by the defendants, and therefore the other tortfeasors had not been released by the compromise. Next, release of one of the joint tortfeasor releases all others as well. इसमें क्या था? The reason being that the cause of action which is one and individual having being released, all persons otherwise liable therefore are consequently released. A mere covenant or agreement not to sue one of them doesn't have the same effect because such an agreement merely prevents the cause of action from being enforced against the particular wrongdoer with whom it is entered into. Next, liability of joint tortfeasors. Joint tortfeasors की liability क्या क्या होती है? Number one, joint tortfeasors are jointly and severally liable. Jointly या severally liable होते हैं. An action may be brought against anyone, any number, or all of them. The fact that claim is barred by the limitation as against one will not in itself free the others from liability. Harihar Prasad versus Bholi Prasad, 1907. Next, courts in India have not necessarily followed the distinction between joint and independent tortfeasors as recognized in England. They are termed as composite tortfeasors. Joint tortfeasors are to be distinguished from independent tortfeasors. The distinction between the two lies in the fact that in case of joint tortfeasors, there is a concurrence not only in the ultimate consequences but also mental concurrence in doing the act, while the case law of independent tortfeasors where is merely a concurrence in the ultimate result of the wrongdoer act independently done. This rule was later, this rule was later, what happened? Abolished by the law reforms. Married Women and Tortfeasors Act 1935. In contrary to previous law, the tortfeasor can now recover contribution from other tortfeasors who is liable in respect of the same tort. While recovering the amount from the tortfeasor, it is essential to make sure that the amount is just and equitable, and in addition to this, it has regard to the extent of the defendant's liability to the aforesaid tort. The court has discretion in any given case to exempt a tortfeasor from the liability to contribute. Next, the important case law, Meriwether versus Nixon. Meriwether versus Nixon. Landmark, where the court laid down that is a common law. A wrongdoer cannot maintain an action for contribution against another wrongdoer, even when the one seeking contribution would have satisfied the full claim of damages. And this is popularly known as Meriwether versus Nixon rule. The rule of Meriwether versus Nixon rule क्या है? Existed and had wide applicability, but it existed with certain exceptions. कुछ certain exceptions हैं.